Welcome, ladies and gentlemen, to the Common Law Court of Wales radio show. We have a special guest, Nige Coleman. Been doing excellent work on formulating grand juries. Can you hear me all right, Nige?
Yes, absolutely splendid. Much easier than the last conversation we tried to have.
That was something, wasn't it? Just for the listeners, me and Nigel tried to touch base yesterday, and it was, well, we tried several different mediums. In the end, the good old landline got it, but somebody didn't want us talking, that's for sure, Nigel. I think I'll leave it at that. What do you think?
Well, yes, indeed. Always leave them wanting more. But no, it's been a long time since I've had that kind of difficulty in establishing contact with someone. It was quite disturbing, really. But well, at least we're able to talk today. So,
grand juries, within a particular critical time in our history where we find the governments and the courts are totally run away and abandoned our law in order to facilitate basically fraud and asset stripping of the people. So where did this concept come? How did you come across this remedy, Nige, and exactly what is it?
Okay, well, actually my first exposure to grand juries, British grand juries, was at the British Constitution Group annual conference in spring this year, 2015, end of February, beginning of March, where John Hurst did a presentation on grand juries, and also as part of that conference, the guys there convened a number of grand juries to consider various charges that were being brought against individuals in public office. And at the British Constitution Group conference there, we successfully had enough people to convene 4 grand juries. And I was honoured to be a juror on one of those juries. Now, of course, I can't talk about what we considered as the jury, because that's part of the grand jury process. But John Hurst gave us a considerable insight into the legal and the lawful conditions, if you like, of grand juries. Because grand juries in England and Wales were removed, they were taken away from us in 1933. There were a number of attempts to kill grand juries prior to that, going back as early as 1848, I believe, where the establishment began to feel that they were suitably qualified to start taking decisions like this away from the people. And as a result of the Administration of Justice Miscellaneous Provisions Act 1933, at midnight on 31st of August 1933, grand juries were repealed effectively. And the authority, if you like, of the grand jury was placed into the hands of magistrates. And so indictments which up to that point in time could have been dealt with by a group of ordinary everyday folk coming together and considering some evidence and determining whether there might be a case to answer, that right was effectively taken away from us. That was somewhat 80 years ago or so. Now, as a result of, obviously, John Hurst being a constitutionalist and constantly looking into law and delving into the Constitution and into the law, and I believe some work also by Michael Bernicia, it was discovered that grand juries weren't properly repealed in 1933. Now, when the grand juries were repealed in 1933, it is a rather interesting little snippet I've got here. Just one MP in the debate for the repealing of grand juries, just one MP spoke up in favour of preserving grand juries. And the Marquis of Hartington said, "Suppose it came to pass that we had in this country a fascist government which created a whole mass of new offences, such as holding views disrespectful of the government. In such a case, the grand jury might be a very constitutional safeguard and prove of immense value." Now, I am sure, Darren, you can see the wisdom in those words, and it's almost like the Marquis of Hartington could look forward 60, 70 years hence and see the situation that we're in now, where we have exactly that. We have a fascist government which is trying to control absolutely every facet of our lives, and it's terribly, terribly frustrating. Anyway, grand juries, as I say, they thought they abolished them in 1933, but grand jury is also a common law right, and you may be able to set aside common law, if you like, put it away, slumbering, waiting for resurrection at some point, but you cannot remove it, you cannot repeal it, and that in itself was one of the saving graces. So, although the grand jury's right to indict people directly was impliedly and explicitly repealed in 1933, the right for a grand jury to make a presentment was not repealed in that 1933 legislation. And this is really important because the right to make a presentment remains unrepealed from Statute the 5th, 1351. And this is one of the key aspects of where grand juries actually can come back into the picture again. Statute the 5th says, "No one shall be taken upon suggestion without lawful presentment, nor disenfranchised but by course of law." Paraphrasing, according to Magna Carta, it says, "It is accorded, assented, and established that from henceforth none shall be taken by petition or suggestion made to our Lord the King or his council, unless it be by indictment or presentment of good and lawful people of the same neighbourhood, where such deeds be done in due manner, or by process made by writ original at the common law." And finally, referring back to Blackstone's commentaries on the laws of England, it says, "The next step towards the punishment of offenders is their prosecution, or the manner of their formal accusation. This is either upon a previous finding by an inquest or grand jury, either by presentment or indictment." And so the crux of this, and the great thing about it is that in 1933 the government thought that they repealed grand juries, and they did repeal grand jury indictments, but they didn't repeal presentments. And so therefore British grand juries, British runaway grand juries, continue to be both lawful in common law and legal in statutory law. And that means that we have some significant power that we can still wield at this point in time.
It's absolutely critical, that, Nige, because there's no bypassing it. As you say, it's not been repealed, therefore it is lawful and legal.
Indeed, indeed. Now, what we first thought, and what was first presented at the British Constitution Group by John Hurst, it was originally thought that it would only be possible for a grand jury could be convened anywhere in the country, but it was understood at that point in time that the presentment which a grand jury, the foreman or the private prosecutor of a grand jury would make, thought it could only be, a presentment could only be made at the Old Bailey, because in the 1933 legislation, grand juries for the county of Middlesex weren't repealed, and therefore the catchment area of the Old Bailey, being Middlesex, meant that in theory you could hold a grand jury anywhere, but the presentment would actually have to be made at the Old Bailey. It's since come to pass that in itself isn't correct, and indeed it would appear that it's possible for a grand jury not only to convene anywhere, but should they find a true bill, that presentment can be made at any magistrate's court in the country. And that in itself is very significant, because a lot of people, I'm sure, would thought to themselves it would be lovely to be able to convene a grand jury and find a case to answer against various persons in public office that have committed misconduct, malfeasance, misfeasance, nonfeasance, whatever. But then thought, well, yeah, but okay, even if we get a true bill, someone then has to drive all the way to London, and you know, we don't all live in London. It's 150 miles away for me, and probably a little bit more than that for you. So, you know, not many people would want to have to drive all the way to London in order to be able to continue the legal process. And so the fact that we can make presentments at any magistrate court means that the possibility for convening grand juries is open to just about anyone, and significantly more convenient than we thought it was back several months ago when this system first kicked off. And just to be clear on it, this is still fairly new territory for us, because no proper grand juries, that were constitutionally convened, hadn't been done before the spring of 2015. I know that there was one sort of held last year under a slightly different guise, but from a constitutional point of view, and using this process, we've only just started holding grand juries again in 2015. So this is new territory. I was fortunate enough to speak to John Hurst a few weeks ago, and that was when I learned that it would be possible for grand juries that the result from grand juries, the presentment, to be made at magistrates' court. I learned that from him then. At that point in time, 3 grand juries had been held, one in South Wales, and 2 in England, one of which was in Worcester. Now, the one in South Wales, the grand jury found a true bill, and the presentment was made at the magistrates' court, and I understand the magistrate rejected it. Now, that's okay. They can do that if they want, but we still have Magna Carta 1215, which remains permanently in force in this country, and we cannot be denied or deferred justice under that. And so what can happen is that if the true bill is taken to a magistrate's court and the magistrate refuses to take it and frame the indictment, then you can either start a judicial review against the individual who has denied you or deferred you justice, or you can convene a grand jury and to determine whether or not that individual is also responsible for malfeasance or misconduct in public office. So, and that's the current state of play as far as grand juries are concerned. They are legal. Oh yes, sorry. The 2 in England. One of them, I don't know what happened, but I understand that the one which was made at Worcester at Magistrates' Court was accepted by the magistrate. Now that is great. That's fantastic, because that's the first bit of solid news that we've had as far as the existing legal system is concerned, that's actually taken the finding, the true bill, from a spontaneously convened grand jury of the people of England and Wales. And I'm sure, Darren, you'll agree that it's good news. It means that it's working, that it can actually do something. But, as it stands, it means that grand juries in England and Wales, or runaway grand juries is their proper title, they are legal and they are lawful. And provided that the grand jury finds a case to answer when it's convened, the result of that can be taken to any magistrate's court and should, in theory, push the individual in question straight into a petty jury trial. So it bypasses the magistrate.
I see.
That, again, is really important, because if, for example, a group of people came together and they had good, solid evidence that, say, somebody had been committed sexual offences against children or something like that, and for whatever reason hadn't been spotted by the existing legal system or the police, the grand jury can come together, they can look at the evidence that they've got, and a runaway grand jury in England and Wales assess evidence to the civil standard on balance of probabilities rather than the criminal standard, because what would happen is that the grand jury, which can comprise between 12 people and 23 people, would assess the evidence at the civil standard to determine whether or not they feel that there is a case to answer. And it's really important for people to understand that grand juries don't have a huge power like they have perhaps in the States. What we have here is that we cannot subpoena people, we cannot call people in a grand jury, we cannot arrest people, and we cannot make judgments against people. That is for a petty jury to do under a criminal standard of law, whereas a grand jury, as I say, convenes and assesses evidence at the civil standard to determine whether or not there is a case to answer. In other words, it's doing the magistrate's job for him or her. So that's pretty much it, really, as far as things go. We have this system available to us. Anyone in England and Wales can convene a grand jury, provided you've got sufficient evidence that would be compelling for between 12 and 23 of your peers to turn round and say, yes, this evidence looks compelling, we think that there is a case to answer, let's take this to court and get this individual in front of a petty jury for a trial for their proposed crimes. And then, of course, it would be for a petty jury to determine the guilt or innocence of the individual in a full criminal trial. And we need people all around the country to go out with genuine, bona fide, and preferably prima facie evidence to convene grand juries against policemen that have misconducted themselves, or local councillors that have been on the take. Anything where you have got a satisfactory amount of evidence that you think would convince a group of your peers. Convene a grand jury, assess the evidence, and if the grand jury, as I say, of between 12 and 23 people agree that there's a case to answer, take that to the magistrates' court and push it forward. Block up the system. Take back your power. And that really, to me, is the great thing about grand juries. Because for so long now, Darren, we've all been dispossessed of our power. They're taking away our right to free speech. You can't say things about ethnic minorities without being possibly at the mercy of some kind of legal law. Now, I'm not proposing for 1 minute that we should say unpleasant things about anyone, but at the end of the day, free speech is free speech, and it's either free or it's not free. And I don't believe that we have what you would call free speech left in this country anymore. So we've had that taken away from us. I see on the horizon now that the government are proposing to take away our right of assembly, and also to produce rules that make it illegal to criticise the government. And that takes us right back to that thing that I said at the beginning, when we first started speaking down about the Marquis of Hartington, who said, suppose it came to pass that we had in this country a fascist government who created a mass of whole new offences such as holding views disrespectful to the government.
Well, that was a wonderful bit of insight. And,
it is, and we've come full circle now. So, but we actually have this power that we can wield to start holding people in public office to account for anything where that they have done wrong, which is criminally wrong. Misconduct in public office, or malfeasance, misfeasance, nonfeasance. Anything where someone has been wronged by the establishment or the system, we can do something about it.
Indeed, this mechanism has been placed there, Nige, for the people in order to hold these people to book. Essentially, this is a part of our law and history which has been put there for times in which we are living now, Nige.
Yes. Can you still hear me okay?
Yeah, we're fine.
Okay, it's okay. I nearly pulled the microphone out there for a second. Yeah, so, and that's the thing, see, we have this right enshrined in both common law and under statutory law as well, and that, it's great because one reinforces the other. If it was just something that we managed to dig up that was only relevant in just statutory law, for example, then a group of judges could have got together and turn around and come up with a viable excuse to get around it and make it not valid anymore. Mm-hmm. It's like the Tom Crawford case, isn't it? That the poor guy's been dispossessed of his house without, and under common law, he's entitled to a jury of his peers for that to take place. Yeah. That's not happened. There's no judgment against him, no warrant against him, no repossession order against him in the court papers, and yet he's been dispossessed of his property. And that alone is a perfect example of where a grand jury could be convened, because so many things went wrong that day, or so many things were wrong that day. The police assisted the bailiffs. That's illegal. They're not allowed to do that under any circumstances. They can only keep the peace. They are there, as enforcers to keep the peace. They cannot get involved in a civil dispute. No, They got very much involved. You can see that from all the videos on there. So, you know, all the people there needed to do was to take the collar numbers from each of the policemen who were obviously operating ultra vires, outside of their own authority. Because as soon as they were doing anything other than keeping the peace, they were no longer constables, and they become private individuals who are liable under common law for their own actions, errors and omissions. And we are all in common law liable for our own actions and omissions. Just because you wear a uniform, it doesn't give you any special power to be immune.
I watched some of the footage and it's quite disturbing, Nige. There seem to be hundreds of police there, and they simply cleared the road in order for the getaway van with all his goods to be taken. It was quite sickening to see.
And I hope that all the policemen that were there can be informed of the way in which they've all been party to misconducting themselves and operating outside of their authority. I wonder how many of the policemen present at that site were aware that there is no judgment against Tom. Because, you know, they're not all bad, Darren.
No, but
at the end of the day, you know, the police the police are human beings like the rest of us, and I know that you know there's a common thread going through society, and maybe in the truth of the environment to some extent, that the police are bad, the police are bad. Right? Yes, some of them are terrible, but a great many of them are just normal, everyday human beings bringing home a crust to earn a living, trying to pay their mortgage like the rest of us, and all the rest of it. And they're not all bad, and if they could be just informed, because you know I've absolutely no doubt that they were all told a pack of lies in order to give them the motivation to go out there and do what they did. And I refuse to believe that all the police are bad. So, you know, sticking with the Tom Crawford case, it is one of the ideal opportunities to convene a grand jury, because any of the police, for example, I've seen on the videos that there are a number of arrests that have been made. I think that some of those arrests have been made on a breach of the peace. Mm-hmm. Well, if you look at the legal definition of a breach of the peace, it's actually quite explicit about the tests that are required in order to fulfil the necessities of being able to arrest under a breach of the peace. And I know that the police are using a breach of the peace as one of those things where they can sort of get people out of the way, and they're overusing that as an excuse to be able to move people on, and it's a great pity. So anyone that was there that day who was arrested for a breach of the peace, you just go and check the lawful definition of a breach of the peace, and it's actually quite interesting. Here we go. The definition of the breach of the peace as used in the UK is that the behaviour of a person involved caused the police or a private citizen to believe that 1. a breach of the peace had or would occur, and that 2. it related to harm which was actually done or likely to be done to a person, or in his or her presence, their property. All right? So a breach of the peace isn't about standing there chanting, shouting at the police, locking arms. That's not a breach of the peace. You can shout and shout and shout. You can, again, I'm not proposing people do it, but you can shout and swear at the police as much as you like. It's not a breach of the peace until there is harm or a threat of harm to an individual or to an individual's property if the individual is present. And so anyone that was arrested on the day with Tom's case, that was arrested for a breach of peace, look at that definition. Was that you? Were you in the process of causing harm or about to cause harm to an individual or their property? I very much doubt it, Darren. And so those individuals could, if they got the collar numbers of the police in question, they could convene a grand jury, and there's no shortage of video evidence, so evidence certainly isn't going to be an issue for that. Convene a grand jury. Were those officers acting outside of their authority by making arrests for breach of the peace when a breach of the peace didn't occur? That could be convened in a grand jury, could assess the evidence, determine whether or not there's a case to answer, and then make presentment at a magistrate's court. Again, bypassing the magistrate. Very powerful, because once people in the system, in public office, get to realise that we, the public, have that power to hold them to account in a way that they have believed they've been able to get away with for years, once they realise, maybe, just maybe, they'll start doing things properly instead of cutting corners, breaking the law, and all the other unpleasantries that seem to come with being in public office these days. Do you agree?
Absolutely, 100%, Nige. And just to echo what you said, not all police are bad, but certainly some of them are. And in the footage I seen in regards to Tom's yesterday, there was a gentleman who was taking caller numbers, and he came across the Sarge. And this sergeant's attitude was stereotypical of the bad coppers, which we see too much of in today's service. And he was awful smarmy, and he was kind of enjoying himself, Nige, in what was a very horrific situation for the most people who was there. Were terribly upset. They could see, there was people crying and things, and this guy was delighted. He seemed to be delighted. Anyway, would be the best way to describe this gentleman's behaviour. And another thing which I noticed on the videos, the police were ordering some folks to go to the protest, the designated protest area.
Yeah.
The police obviously had knowledge of it, but they hadn't given Tom any or anyone any legal they were under a legal obligation to provide the Crawfords with notice that any repossession was to be made.
Yes.
Obviously that did not occur.
No.
But the police obviously knew. But furthermore, they had designated areas to which people could protest, and they kind of kettlebelled them in there.
Mm-hmm.
So, I mean, they're using insidious tactics here in order to suppress the people, to facilitate the fraud and theft of another man's home. It's going on every day, but where Tom's case is unique is that there's so much awareness and people keeping an eye on Tom's case. Your everyday man doesn't get the coverage and the attention that Tom's case has got, Nige, so this could be used in a positive as far as gaining justice through legal and lawful means,
yes.
Peacefully, and holding these people to account. We are doing it the right way, Nige.
Well, like I say, at the end of the day, we have a constitution in this country. A lot of people don't realise that Britain has a constitution. Well, it does. It's not a written constitution in exactly the same way that they have over in the States, where it's all in a single document. But, it's just across a number of specific documents, such as, you've got Magna Carta 1215, forget 1297, which is the one that the government keep pointing us at all the time, 1215, which is beyond the reach of Parliament, because they were never a party to that treaty, so therefore it can never be changed or repealed by them. It can only be added to with the consent of the people. So you've got, as I say, the British Constitution comprises Magna Carta 1215, the Declaration of Rights 1688, which was then put into the Bill of Rights 1689. And the Act of Settlement, and a couple of others, the union between England, Wales and Scotland. But those documents essentially make up the British Constitution, and in fact, if you look at the American Constitution, some of it is actually word for word for what you'll find in either Magna Carta or in the Bill of Rights, literally word for word some sections. So, yes, we have a constitution. It is a law. We have constitutional law. And everybody, absolutely everyone in the country is obliged to follow it. So yes, let's use the momentum that this unfortunate case with Thomas caused. Let's try and, rather than having all the anger and despair, which obviously to some extent comes with it, and people being afraid of what might happen in the future, let's try and change those emotions, convert those emotions into something positive, into momentum, and keep the ball rolling, keep it in the public eye. So, some of those people that were at Tom's, please convene a grand jury, and if there's a case to answer, take it to the magistrates' court and get the individuals before a petty jury to answer for their crimes as to whether they're guilty or innocent. Let's do it. As a people, we have the right. and we really must use it. As far as grand juries are concerned, I know that I've had, obviously because of the amount of publicity that I've had and the YouTube video and everything, there is a lot of disinformation floating around about the grand jury. So one of the things one of the myths I'd like to dispel is the oath. Is in order to sit in a grand jury, the grand jurors must swear an oath in a similar way to which you would swear an oath in court, but it's not the same oath. And I want I want to enforce the understanding that the grand juror's oath is not religious. So one of the pieces of disinformation going around is that you've got to swear on the Bible. No, you don't. Not for a grand jury. So, with your permission, what I'll do, it's only about 30 seconds long. I'll actually read to you the grand juror's oath, so that people know what it would be that they would be swearing to in order to proceed as jurors. You good with that?
Please do.
Yeah. The grand jury oath. I, insert name, as a grand juror for England and Wales, do solemnly swear or affirm that I will diligently inquire into all matters according to my duty. I will make true presentments of my findings. I will not disclose the nature or substance of the deliberations of the grand jury, the nature or substance of any testimony or any other evidence, or the vote of the grand jury. I shall not make a presentment against a person because of envy, hatred, or malice, and I shall not fail to make a presentment against a person because of love, fear, or reward. Now, if that's not a non-religious oath, if you see what I mean, it means that it doesn't matter what your religious background is, whether or not you have any regard for the Bible is completely irrelevant. The grand jurors could all be Sikhs or Muslims or anything. It really doesn't matter, and that's the great thing about the grand jury, is that it's universal. Anyone can sit, as long as you don't have a serious criminal record. And when we say a serious criminal record, what we're talking about here is common law, not statute law. So it's harm, fraud, or injury effectively against an individual. If you've injured or committed fraud against an individual, then you shouldn't be sitting on a grand jury. But if you don't have that behind you, which of course is 99.9% of us in the population, then there's nothing stopping you from convening a grand jury. So that's the main myth that I wanted to dispel, is this thing going around that there's a requirement to swear on the Bible. There isn't. So it really doesn't matter what your background is. So anyway, as far as the grand jury is concerned, I think you wanted me to mention about its general way in which it's convened. Is that right?
Yes, please, Nige.
Yep. Okay. Right. Well, effectively, serving on a grand jury, it's a duty, if you like. It's an ethical duty, but it is a voluntary, and here's a very important point, an anonymous act. All right. People who sit on a grand jury, your names are never taken, ever. Nothing is recorded in the grand jury. There are no recordings of any kind. No, it doesn't matter. It's not paper. It doesn't matter whether it's electronic or any other format, camera, audio recorders. There nothing, absolutely nothing is recorded. So if you sit on a grand jury, then it is an anonymous act. The only person who might be vaguely identifiable, if you like, is the foreman of the grand jury, who would sign the true bill, but it's a signature. So again, it doesn't exactly have to be legible. But apart from that, the individuals that sit on the grand jury, you're completely anonymous. The minimum age, now this is an interesting one, and has again proven a little bit problematic for some. The minimum age is 21. Now, this might sound a little bit odd, especially given the fact that we all know that the age of majority now is 18. But when the grand jury, the idea of the grand jury first, came into being. We're talking about 800 years probably, or maybe even more now in some cases. Everything was based around common law, and in those days, the age of majority was 21, and the age of majority was only brought down, I think, somewhere around about 1918. I forget a particular piece of legislation that did that now. And that brought it from 21 to 18. But in order to be absolutely certain that the grand jury is convened constitutionally, it's recommended, I would say, that all members should be at least at the age of 21. And that safeguards any possibility of there being a fault in the process, which is what we want to avoid. So essentially what you get, an individual or maybe a group of people who you could loosely describe as a private prosecutor would prepare a charge or a list of charges relating to a defendant or a group of people, small group of people or whatever, and their alleged crimes according to the known or the suspected facts. So, for example, going back and looking at the Tom Crawford case, there were probably incidents where police officers arrested people at Tom Crawford's case for breach of the peace, when in fact this clearly wasn't a breach of the peace taking place under common law. So that group of people would be aware that there is a potential crime to be investigated. So a private prosecutor would sort of prepare a piece of paper broadly outlining did Mr. or Mrs. XYZ committed or is alleged to have committed a crime on such and such a date at such and such a place. And that is effectively, if you like, historically, that is called the bill. It is what might otherwise be described as possibly the charge sheet at a police station, or the formal charges against you in a magistrate's court. So that is called the bill, and that's a piece of paper where the identity of the individual is recorded along with the crimes that they're alleged to have committed. There are two ways of proceeding from that point. Either, if there are already a group of people or a sufficient number of people convened at that location, then they could spontaneously then just form a grand jury with any background information that they already know about. Alternatively, a broad outline of the evidence against that individual or the group of people could be presented to an open group, to a meeting of people, which could be specially convened for that purpose. So let's just say that someone's going to call a public meeting where they're going to describe some of the broadly speaking, some of the crimes that the individual or the group may have committed. And then from that assembly, the grand jurors can be randomly selected, having volunteered, of course, to convene. Now, the constitutionally convened grand jury in England and Wales, it can be no less than 12 people, and it can be no more than 23. And what we actually have is the way in which the grand jury works here. Under common law and the traditional grand jury setup, there is no concept of a majority vote. What it requires is 12 people, 12 of your peers, in the same way that in a petty jury it's 12 of your peers. So if you've committed a really serious crime, for example, the standard of evidence ultimately is really very high, because let's say, for example, that somebody in your locality has committed a heinous crime like murder, for example, and a group of people who are aware that this has taken place, some of whom have got evidence, etc., they convene and they consider the evidence at, as I said earlier, the civil standard on balance of probabilities. At least 12 of their number must agree that there is a case to answer. That then goes to a court where a trial is initiated, and another 12 people, a jury of his or her peers, or the murderer's peers, would then consider the evidence at a criminal standard. So it can take 24 people, 24 of your peers, in order to find one individual guilty. So ultimately, the standard of evidence is actually quite high when you look at it that way. So with a grand jury, there can be no less than 12 and no more than 23, but it requires only 12 out of that group to believe that there's a case to answer in order for it to move on to the next stage. Once the jury are sworn in, they can read pre-prepared witness statements, which relate specifically and only to the defendant or defendants and the crimes that are alleged on the bill or the charge sheet, if you like. And supporting evidence can be considered. If there are any live witnesses present at the venue, the jurors are informed that witnesses are available, and the grand jury can call the witnesses in order to be able to clarify witness statements if there are any questions arising after the witness statements, because sometimes you can read something and it doesn't always necessarily make sense. So if there is a live witness present, great, you can proceed on that basis. Obviously, again, there's no legal requirement to attend, so you can't demand that a witness attends. That's something that a grand jury can't do. It's all done voluntarily. So the jury would summon a witness if they're available, ask some questions about the parts that they don't understand, and then the witness would be removed from the room so that the jury could continue their deliberations on the matter. During the course of the grand jury, if any juror discovers that they're in some way connected with the case, or they feel that they can't remain impartial, then they must recuse themselves and leave the room. And of course, if they do that, then they are prohibited from discussing any of the evidence that they may have already considered. As the deliberations continue, the deliberations don't need to keep continuing until you've trawled through all of the evidence. At any point during the course of the grand jury, if the jury spontaneously believes that there is cause to vote on whether or not the individual is potentially, if there is a case to answer, then the foreman can be elected and a vote can be taken and to determine whether or not 12 of the jury's number agree that there is a case to answer. So, as I say, that can happen at any point throughout the process. So it's not a question of having to sit down with hundreds and hundreds of pages of evidence and have to go through all of it in order to determine whether there's a case to answer. You only need to look at enough evidence to a point where everyone, or at least 12, are in agreement that there's a case to answer. At that point, you can call a vote, determine whether there are 12, and if there are 12, then basically what you're doing is you're presenting the defendant for indictment. And so if, when the vote is cast, 12 people within the jury agree that there's a case to answer, then the jury foreman will write the words on the face of the bill, the words "true bill," and would sign and date it in front of the other jurors who act as unrecorded witnesses, if you like. If less than 12 votes are cast in favour of presenting the defendant for indictment, that is the end of the grand jury. Nothing else will continue. Now, interestingly, one thing that does come out of that is that if the grand jury eventually decides that there isn't a case to answer, then there is nothing stopping the individuals from going on and discussing the matter with other people. It's possible to discuss the information that you've received. I would discourage it, but ultimately there's nothing to stop you. But if the grand jury does find 12 individuals voting in favour of making the presentment, then all the jurors present are sworn to secrecy. You must never ever divulge the content of the deliberations or the vote of the jury, i.e. how many individuals voted one way or not. That remains private and is not recorded and should never be discussed. So that pretty much sums it up. In summary, a group of people can spontaneously come together, between 12 and 23, to look at some evidence to see whether or not they believe that there is a case to answer. assessed on a balance of probabilities at the civil standard. You determine whether or not that an individual may have committed a crime, or whether you think there's a case to answer in a trial. And if the 12 of the number agree, then the individual should then be, the true bill is presented to a magistrate's court where, and this is quite important, an officer of the court, doesn't have to be the magistrate, an officer of the court is required to frame the indictment. And that is critical, that a particularly critical part, okay? So at the end of the grand jury process, what you've got is the individual who you could loosely describe as the private prosecutor has got this piece of paper which says true bill. And that individual would then go to a magistrate's court and make a presentment. And it's imperative that the word is used is presentment, because presentment is the mechanism that was not repealed when they thought they took away grand juries from us. So the private prosecutor goes to the magistrate's court to make a presentment. And an officer of the court is obliged, I repeat, obliged to frame the indictment. In other words, basically moving that true bill and taking the case into a jury trial. That is a requirement. Now, if the officer of the court, whoever that may be, refuses to accept the presentment, which is entirely possible, then you have two choices. You can, and also don't forget to inform the individual in question that you can either start a judicial review against the individual for denial or deferral of justice, which is our absolute right under Magna Carta 1215. And again, as I say, it's something, because Magna Carta 1215 can never be repealed or changed in any way by Parliament, it's an absolute right that is enduring. So you can start a judicial review against the individual for a refusal to, or denial or deferral of justice, or you can convene a grand jury to determine whether the individual who's refused to frame the indictment is responsible for misconduct in public office or malfeasance. Because if they're not doing their job, then having particularly usually an oath of office or whatever, they have an obligation and a duty of care when a crime is being reported. If they're refusing to do that, then you can convene a grand jury to determine whether or not that individual is also potentially responsible for a crime. And one could then either take that true bill and presentment to the same magistrate's court or to a different magistrate's court, whilst still possibly pursuing the individual under a judicial review. So we have several directions that we can come at these people.
Yes.
And it's really important that we grasp this with both hands as vigorously as possible and try to move forward with it. Not in any haste, but we have it, so why not use it? It's like our British Constitution. If we don't use it, we will lose it. And the government are in the process of putting together a new Bill of Rights, which they have no authority to do. So they're trying to take away all of our rights and replace them with revocable privileges. And that, Darren, is simply not on. No. So let's convene a grand jury against any person in public office who has potentially or allegedly committed a crime, and get them into the system in one way or another. At least it's been recorded then, hasn't it, officially? We should be able to move forward with some kind of recovery of justice back to the people from the psychopathic criminal elite that seem to be fully in control of our destiny at the moment.
Yeah, perfectly put. You mentioned at the start, Nige, that this all goes back to Magna Carta 1215, and along with the right to convene runaway grand juries is the right to have a fair trial, jury by your peers, and they are still on the books as lawful and legal to this day. Now, there's also another part there that is vital in fighting back what is turned out to be a fascist Nazi regime in which we're living in today. This year, just to facilitate the greed of multi-corporations, and it's just sickening. But there is other ways of fighting back, Nige, and I'd like to touch on lawful rebellion, Article 61. Okay, so again then, Nige, we have these mechanisms that have been placed there by our forefathers who had the foresight and wisdom to place these mechanisms within law to protect us from the tyrants in which we face today. Along with these other mechanisms of grand juries is a little thing called Article 61, which is lawful rebellion. Could you go into that a bit and how people are duty bound to invoke that in the days we are living in today?
Well, thanks very much for excuse me again. Thanks very much for bringing that one up, Darren. It's actually the thing which is probably closest to my heart, and I openly declare that I am standing in lawful rebellion and have done for some considerable time. Basically, under Magna Carta, as I said just now, under Magna Carta 1215, which is a treaty which is beyond the reach of government. It is beyond the reach of Parliament. They can never do anything to it in any shape or form. It stands for eternity, and it is part of our Constitution. And as you pointed out, it effectively declares, or no, it reasserts some of our rights. And one of the things that I'd like to reinforce here is a lot of people who turn around and say, "Oh no, Magna Carta, Magna Carta. You can't give rights. It doesn't provide you with rights." No, Magna Carta 1215 reasserts the pre-existing rights that we had, eternal, unalienable rights that we've had and we continue to have. So it's important to remember that Magna Carta doesn't give you any rights so much as it simply reinforces those that we already have. Now, Article 61. Article 61 was put in place so that should the people of the country find themselves under the rule of a despotic government, that there would be some form of redress, some way in which the people could obtain a remedy against a fascist government. And to sort of boil it down as simply as possible, what it simply says is that you have the right to declare or to stand under Article 61, which gives you a lawful excuse in order to commit lesser crimes, that's crimes lesser than treason or murder or anything where harm is involved, in order to distress and distrain the government or the crown, to make it extremely difficult for them. So with Article 61, the actual process that takes place, well, first of all, I should reassert that Article 61 was invoked on behalf of the people in March 2001. I won't go into the elongated history of it, but effectively, at the behest of the people, the Barons Committee was invoked and convened, and of their number, they took a vote and they decided that it was unacceptable for the Queen to give royal assent to us, as in our government, signing the Nice Treaty, because they realised that actually our entry into the European Common Market, as it was called once upon a time, was an act of treason. And in fact, there's public domain evidence that you can track down. It's quite easy to find. It's called Shoehorned into the EU. And it's a collection of documents that were released under the 30-year rule, which demonstrate quite clearly that the Heath government between 1970 and 1972 committed acts of treason in order to get us into the European Economic Community. And each government that's been convened subsequently have actually added to, or in some way aided and abetted that treason and committed their own treason by the signing of subsequent treaties. And so the Barons Committee, at the behest of the people, was convened. I think it was 1999 they first convened, but in 2001 they sent a petition to the Queen stating that we believe it would be an error for you to give royal assent to the signing of the Nice Treaty. The Queen had 40 days to answer the petition adequately and within constitutional law. She answered on the 39th day, but without an appropriate answer. And so as a result of that, on the 23rd of March 2001, the Barons Committee invoked Article 61 of Magna Carta. And that placed us in the expression which is now quite commonly used is lawful rebellion. And actually that term didn't exist back in those days. That's a term which surfaced sort of 2005 to 2006. And the important thing is that this country has remained in that condition under the invocation of Article 61 or lawful rebellion. We've remained in that condition since 2001. It has never been revoked, it has never been addressed. Therefore, up to and including this day and beyond, we still are in lawful rebellion. Now, the important part of this is that the individual can switch your allegiance from the monarch. And I know this is a problem for some people because obviously there's a great deal of sentiment about anti-monarchy and the monarchy's potential involvement in paedophilia and stuff like that. But for the time being, let's just accept the fact that for now, this country is a constitutional monarchy. That is our constitution. That is our underlying law. Under common law, we are a constitutional monarchy, where, in theory, the monarch keeps Parliament in check, and Parliament keeps the monarch in check. And the monarch is the defender of the people's rights, liberties, and the common law. Now, of course, we all know that that's gone horribly wrong, and the Queen has probably committed something like 2,500 counts of treason. But, just setting that aside for a minute. Because the Queen failed to deliver when the Barons Committee made the petition, which then placed us into a state of lawful rebellion, what we can do as individuals in this country, and what we have a right to do under Article 61, is to switch our oath from the monarch to the Committee of the Barons. Now, this is one area which is full of a great deal of misinformation, and I get a lot of people contact me privately, particularly through the website lawfulrebellion.info. People say, well, I don't want to give my oath to a baron. And it's really, really important that you understand that you're not giving your oath to anyone, individual, or to even the group of barons. What you are doing is you are switching your oath of allegiance from the monarch, or the office of monarch, to the Committee of the Barons, which was convened on behalf of the people. So you're not swearing an oath to a baron or to the barons. What you're doing is you're swearing an oath to the Committee of the Barons that was formed on behalf of the people in order to find redress against a crime that was being committed, and that crime being the crime of treason at common law. So what we do, it's quite simply, lawfulrebellion.info has got templates on there where you can simply download the oath and fill out, find the address of one of the barons that's also on the website. You can fill the oath out and then have it witnessed, sign it, witness it, and then you post that off to one of the barons that is in the list, which was one of the barons who was part of the Barons Committee when it was invoked. Now, some of them have since died, because it was back in 2001 that Article 61 was last invoked, and some of them have changed their mind and run away. But that in itself is a side issue. The committee was formed, and Article 61 was invoked, and that's the important part. What we do by signing and witnessing and sending off the oath is proving our allegiance, proving that we've switched our allegiance from the Crown for the time being. And therefore what we're doing is we are denying the Crown any lawful authority over us. And I know it's been a bit long-winded to try and get to this point, but the actual purpose of this is that we, each of us who stand under Article 61, have this thing called lawful excuse, where we can distress and distrain the Crown. And what the purpose of that is that we make life extremely difficult for them, wherever humanly possible, within the remit of not causing harm or fraud to anyone in particular, of course. So it's things like refusing to pay tax, refusing to pay council tax, income tax, VAT, duty, refusing to pay any kind of tax, refusing to comply with instructions from the police, because again, they are a Crown authority at the end of the day. Once you send off your oath and have effectively declared yourself standing under Article 61, any Crown, in inverted commas, authority has no jurisdiction over you. So that includes the courts. And I'll give you a classic example here, is that one of our number in Glastonbury, she was a bit naughty and completely disregarded a whole bunch of letters coming to her regarding the non-payment. I think it was for water, and eventually it went to court, and she didn't bother. She just binned the letters, didn't bother. The letters kept coming. Eventually, the court grew tired of this, by which time this individual had submitted her oath and was standing under Article 61. And they issued an arrest warrant. And they wrote to her and said, right, we've issued an arrest warrant. You have, I think I can't remember if it was 12 days, a certain number of days to report to the court in order to receive your punishment, which was 7 days in prison for contempt of court. So, just to clarify that, right, she was ignored the summonses, she ignored the conviction and the letters that came with it, but during that process at some point stood under Article 61 lawfully by submitting her oath. When the letter came telling her that there would be an arrest warrant, she wrote back with a conditional acceptance using Article 61. I conditionally accept the demand that you're making on me upon proof that you have any authority whatsoever since the invocation of Article 61 in 2001. And it went away. The arrest warrant went away. The 7-day prison sentence went away. It just vanished. Now, if that isn't power of the people, then I don't see what is. Can you imagine any court just taking receipt of a letter, trying to plead mitigating circumstances or whatever? Can you imagine any court taking hold of a letter, reading it, and then saying, "Oh, we're not going to bother with this case anymore"? It doesn't happen. So quite clearly, what we've done is that we've now got a de facto proof that not only can we prove beyond any question of a doubt that Article 61 was invoked, but we've also proven that the courts have no authority over anyone who is standing under Article 61 lawfully. And by this mechanism, it gives us a way of chipping away at the establishment and making them realise that they aren't the ultimate power. Last year, I think it was November 2014, the Lawful Rebellion group in Glastonbury seized the town hall. They put the councillors on notice and attended some council meetings where they were berated and poked fun at, and eventually they lost patience and they said, right, we're seizing this building under Article 61. And the councillors, of course, all said, no, you can't do that. That's all a load of nonsense. There's only three clauses left from Magna Carta, because, of course, whenever anyone from in government or in politics, whenever they talk about Magna Carta, they always talk about Magna Carta 1297, which was put into statute, and then the clauses one by one subsequently repealed. But they're wrong. They're right that the clauses of 1297 were repealed, but 1215 still stands unrepealed and can never be changed. So eventually the councillors obviously grew weary of the fact that their meeting was being disturbed, and they called the police. The police came, and they read and saw the proof that was put before them about the legitimacy of Article 61, and the police left, saying nothing to do here, it's not outside of our jurisdiction. So, back in the end of last year, we proved quite categorically that Article 61 is real, is invoked, and it has power. And the groups successfully seized the building using the clause within Article 61 that you can distress and disbrain the Crown by seizing their castles and their assets, if you like. So they seized the town hall, and it worked, and they proved that it worked. And then early this year, the female person that I was talking about just now with the case, the legal case, not only rebutted the arrest warrant, but rebutted a 7-day prison sentence under the power of Article 61. So, we have a power over our so-called authorities that they dislike immensely. And as I said, thank you, Darren, for allowing me to bring this one up. I find it's really, really important that people who are activists, particularly people who are activists, if you take a quick look at the information that's on lawfulrebellion.info, you can see it's just put out very, very simply what the legal situation is, what the lawful situation is, what rights we have, what rights we don't have. In effect, once you submit your oath, you are operating in common law. You're taking yourself out of statute law because you have lawful excuse to break any laws as long as it doesn't injure or harm or cause fraud. So you take yourself completely out of the statute law system and into common law, where you are liable for your own actions, your own omissions, your own errors, etc. But you're free of all the nonsense and the rules and the regulations and the statutory instruments, and it just goes on and on and on. What are there? 9,500, nearly 10,000 laws that we have in this country now on the books. I mean, how can we all know them? They say ignorance is no excuse in law. So we're probably breaking the law now by talking to each other, drinking coffee or something. Do you know what I mean? There are so many of them. We don't know what they all are. And it's become so verbose and so ridiculous that nobody, even people within the legal system are struggling to deal with it on a day-to-day basis. So by submitting your oath and standing in lawful rebellion under Article 61, you're taking yourself outside of the statutory law system. You have lawful excuse to commit offences, not crimes, offences, which would be offences in statutory law, if you like, to make a complete and utter nuisance of yourself. So, for example, for me, I stopped paying my council tax and declared Article 61, of course. And the local authority, needless to say, are pursuing me, liability order, blah, blah, blah. But, they can do whatever they like, because at the end of the day, they can convene a court, which is not a court anymore, and hasn't been since 2001. They can convene a court, which is actually a corporate hearing, and I will rebut it. They can invite me to attend their corporate hearing, or the summons, and I will rebut it. I accept your demand upon evidential proof that you have the authority to issue that demand since the invocation of Article 61. And they're stumped, because they can't. They have no authority. When Article 61 was declared, or was invoked in 2001, at that point the government should have been dissolved by the Queen. But it wasn't. So now we've got this ridiculous situation where every government that's come into, in inverted commas, power, I prefer to say office, since 2001, hasn't been a legitimate government. Every law passed since 2001 has not been a legitimate law, because they had no authority to enact these laws. And it's a fantastic piece of British history, if you like, that our ancestors put in place for precisely the circumstances that we find ourselves in now, where we have a fascist government. And I keep on harping on about it, but I think it's a fantastic passage from the MP in 1933 who stood up and argued about not removing grand juries. Now, I suppose it came to pass that we had in this country a fascist government who created a whole mass of new offences, such as holding views disrespectful to the government. In such a case, grand jury might be a very constitutional safeguard and proof of immense value. So, we have on the one hand grand juries, which we can convene and hold our public officers to account for their misdeeds, and on the flip side of the coin, We can stand in lawful rebellion and refuse to consent to the stuff that the government is doing at the moment. You know, dropping bombs on people's heads over in Syria. Not in my name, you know. And I'm sure that everybody, you know, that listening to this would feel the same. You know, not in our name. It's just not on. I'm not saying it's an easy path to tread. You know, you might need a little bit of courage just to see it through to the end. But Article 61 and lawful rebellion, contrary to reports by some people that it's completely useless. And also, I'd like to point out that standing under Article 61 and lawful rebellion has nothing to do with the Freeman mentality and movement, which, you know, once upon a time, you know, maybe 6, 7, 8 years ago, maybe even 10 years ago, it had some effect before the courts caught on to the tricks that were being employed by the whole Freeman thing. And another thing that I want to point out is that Article 61 is not a get out of debt free mentality. It's not. Its purpose is not to prevent you or for you to escape from paying your lawfully due liabilities. It's not for that. You know, you can't turn around and declare yourself under Article 61 and then refuse to pay your landlord, your private landlord, rent because he's not standing under Article 61. I know that there are some people who say that you know, under lawful excuse we have the right to even breach contracts. I don't think that that's a wise direction to go, to be perfectly honest. And you know, it's only going to be hurting other people who might ultimately join in the cause themselves. So, as I say, we've got grand juries on the one side, and we've got Article 61 on the other side, where what we can do is we can use the grand juries to go on the attack and find cases to answer against people in public office who have committed crimes. And then when the establishment comes after us, we have the shield of Article 61, where we conditionally accept their demands on proof that they have any authority since the invocation of Article 61 in 2001. And to my knowledge, no court cases that have been rebutted have come back to this day. So, I mean, David Robinson, who's obviously been doing this a lot longer than most, you know, I think he's been probably doing lawful rebellion for well, almost since 2001, I suspect. You know, he's been arrested numerous times, and they've issued summonses and things, and he's rebutted them, and you know, ultimately they go away. But it does require just that little bit of courage if you want to take that step. And another question that often comes up about Article 61 is, can I do it if I'm on entitlements, otherwise known as benefits, but to some people, but we know them as entitlements because you know, if you're in hardship, then you're entitled to some help, but from your fellow human beings. So they are indeed entitlements. You know, some people say no. If you go into Article 61 and you can't use the NHS and you can't claim your job seekers allowance and stuff like that, that's all complete utter nonsense. Because if you're standing under Article 61, you can do anything you need to do to survive under duress. All you need to do when you're signing a document is install the initials VC before your signature, which indicates that everything that has occurred before your signature is effectively done under duress. And I know that on the Facebook group Practical Lawful Dissent, there's a guy on there, Sean Shorty, at Catholic, I think. And he's recently been through the mill with his entitlements being stopped, and he actually signed on his documentation VC and claimed, you know, I'm standing under Article 61 and, you know, I'm applying for these entitlements under duress. And they reinstated his money. So, you know, don't be afraid that by just simply submitting your oath and standing under Article 61 that you suddenly lose the right to use the services that we need to use on a daily basis to survive. You know, we still need to use cash machines, although we might not like banks very much, and we know obviously the bank's not under Article 61. If we have an accident, we still need to use the NHS. And I mean, okay, arguably you can stop paying your tax and your national insurance and stuff like that. But in many instances, not paying many of those taxes is not an easy thing to accomplish. You know, it's really hard for an average everyday bloke or woman to go into a shop where they charge VAT on goods and say, right, you know, here's your money, but I'm not paying the VAT. You're just as likely to spend the next 3 hours of your life arguing with the shop attendant and not really getting anywhere. So, you know, not paying some of the taxes is not always feasible. So, you know, if you need to use these services, then you can use them under duress. So, you know, NHS, the doctors, any public services, effectively, that are operated by the Crown, for example, any of those, you can stand under Article 61 and you can use them. But in your mind, if you like, you don't need to openly declare it necessarily. You're doing it under duress until such time as those organisations also stand under Article 61. And to wrap up on that, it's quite an important feature that I should bring to people's attention. Article 61 does state that if it is invoked, then each of us in this country under our British Constitution have a duty to compel everyone else to stand under Article 61 too. Now obviously, you know, the word compel raises some rather unpleasant ideas as to how one might accomplish that, but you know, inform and educate is the way that I interpret the expression compel, because I don't have it in me to compel my next door neighbour to stand under Article 61. You can lead a horse to water, but you can't make him drink. So, you know, each of us have a duty. Once Article 61 has been invoked, everyone in the country is required to stand under it. Because if everyone in the country stood under Article 61 and under the British Constitution as a consequence, imagine what we could accomplish as a people. You know, at the moment, all we've really got are trying to take the public officials to court using the conventional court system. I mean, look at poor old Michael Doherty, you know. How long has he been pursuing his private prosecution against the IPCC? Was it getting on for 6 years now, Darren?
It must be.
Yeah. You know, and power to his elbow, and I really hope that he actually accomplishes something. But you know, it's an unfortunate truth that you know, they're just going to tie him up in knots and sap his money and his energy until there's nothing left. And there has to be a better way. And for me, the better way is Article 61, because you're standing under the law of this land. You know, England and Wales. I can't say specifically about Scotland because obviously with the Act of Union there's some argument about quite how applicable common law is up there. From the British Constitution Conference, I understand that actually Scotland does have common law, and I'm really pleased to hear that. I haven't heard any more about that, but you know, for now, just speaking about England and Wales specifically, you know, we have Article 61 in place. It gives us a power to take back the control of our environment, of our political environment, if you like. Now, well, I've put the chief executive of my local authority, the people to whom I normally pay council tax, used to pay council tax, I've put him on notice that I intend to seize his building at some undetermined point in the future. Because under Article 61, we have the right to seize buildings and assets. We have a right. It's not a privilege, it's a right. Remember, Magna Carta was restating our rights, not giving them. And what I would like to see is people all around the country standing up for what is right, standing together and using Magna Carta Article 61, Magna Carta 1215, Article 61, as their shield, and saying, right, we're not putting up with the psychopaths and the sycophants who follow them. We're not putting up with it any longer. I'm standing under the British Constitution, and if necessary, I will do whatever it takes within the law of the land to bring this country back from the precipice upon which it's standing at the moment. And I think just to finish off on that subject, my latest thing that I'm actually trying to accomplish right now is obviously all villages, towns, cities all have town city councils who meet on a regular basis. And as I said, last year Glastonbury were put on notice that they would be seized if they didn't actually adhere to the law and stand under Article 61. They didn't, so the town hall was seized. Yes, they gave it back at the end of the day because they weren't prepared for a long stay, and they didn't want to inconvenience the cleaner of the building, who was actually a really nice guy at the end of the day, and he wanted to go home for his tea. So it would be hardly fair for them to mess up his day like that. They were making a point. They were proving that it worked. So what I would like people to do, especially the listeners who are currently already standing under Article 61 and understand the consequences of what it means to stand under Article 61, and of obviously having lawfully submitted their oath in order to be able to prove intent that they stand, is I'd like people to start attending the town city council meetings as soon as humanly possible. And I know these days you're only given 3 minutes to talk at council meetings now, which is a bit cheeky really, but that's their system, so let's roll with it. And what we've got on coming up very soon, the Glastonbury guys will be going to the town council meeting there, and we'll be giving a couple of minutes spiel on Article 61, and then asking each councillor where he or she stands on the matter of Article 61. And I'll be doing the same at the Shepton Mallet meeting, which is coming up on the 14th of July. And what I would very much like to see is the other people all around the country who are currently standing under Article 61 to find out when their next town council meeting is. If you've got enough time to, so you've got to kind of submit your idea in advance to give them some kind of clue as to what it is you're going to be talking about. Now, I want to talk about the British, ask a question about the British Constitution and European integration. So that was my, that was my explanation for what I'm going to be saying at the town council. So for everybody to do exactly the same thing is to just, put in a quick email or whatever to your town council saying, I'm going to be attending the next council meeting, and I'm going to be asking a question on the British Constitution and European integration, and then give a 2-minute presentation on Article 61, when it was invoked, why it was invoked, what the consequences of its invocation are, and then ask the councillors who are present at that meeting where they stand under Article 61. Now imagine, Darren, if we could get, say, 150 people around the country. I mean, bear in mind that our Facebook group, Practical Lawful Dissent's got just over 7,500 members. If we could get 150 people around the country to go to their council meeting, the next council meeting, stand up and give a spiel on Article 61 and ask the councillors where they stand under Article 61, can you imagine the number of eyebrows that would be raised? It's all part of an inform and educate, if you see what I mean, Darren. It's, if we could just get the message out, and I suspect that most councillors are not part of the whole truth and movement. They haven't woken up. They don't know what's really going on. They don't know about Agenda 21 and what it means for us in the future, and the fact that the European Union was actually a brainchild of the Nazis in 1942. They don't know this stuff. So let's educate them. So those who are currently standing under Article 61, or those of you who feel brave enough to submit your oath now and then go to the next council meeting, if you've read up enough on it and feel confident enough about it, go to your council meeting, ask the councillors where they stand on Article 61, because each council meeting will have 10, 12 people in attendance from the actual council itself, and possibly more from members of the public who are also present. It will get a message out, and it will get it out in a very, very strong way. If we could just manage, say, 150 town councils around the country or more, it would be fantastic. And the result for our ability to inform and educate and wake people up, Darren, I think is it would be monumental, and I do feel really strongly about that. And I hope that perhaps we can get enough people to be prepared to stop being email warriors and actually stand up and do something. Because all it takes is reading something from a piece of paper for 60 seconds or whatever, or 120 seconds, and then asking your counsellors where they stand. That's it. You don't need to do it anymore. The message has been delivered. And that's my thing right now. I want to create a Mexican wave of people going to their town and city councils and asking their councillors where they stand on Article 61. If we can keep that up, very soon the message will get out.
Indeed. It's very powerful yet very peaceful, Nige, and
yes. It's what I love about Article 61. The trouble with the expression lawful rebellion is that it invokes pictures in your mind of riots and things like that because of the word rebellion. It just does that. It's nothing you can do about the images that it invokes in your head. But the beauty of lawful rebellion is that, and when we say lawful rebellion, certainly those of us in the movement, we actually prefer to call it peaceful lawful rebellion, because it requires absolutely zero violence to achieve its end goals. You can seize any Crown property under Article 61, and again the word seize does tend to invoke maybe some unpleasant images, but it doesn't require any violence whatsoever, because what will happen is you stand up, you say, I'm seizing this building under Article 61. Inevitably the people there will not be very happy about it. They'll call the police, and provided the individuals in question have done their homework and they've got the proof, they've got, like, for example, the petition that was sent to the Queen and the Daily Telegraph article that was published on the 24th of March 2001, proof that lawful rebellion was invoked, and proof that we have lawful excuse, the police will leave, and they'll leave you alone. And if they do arrest you, they're actually, once you stand under lawful rebellion, they're arresting you unlawfully and effectively raising the whole question of treason. And that's where we need to go ultimately, unless the whole country can all stand up together at the same time, go and seize the buildings and effectively take over the country, and there's certainly not enough of us out there to be able to do that at the moment. The only alternative for us is for one of us to stand up with our heads so far above the parapet that eventually it gets us into court, and rather than rebutting the court, it will give us a platform to actually bring the treason matter into court. Because once we prove that treason has taken place in a court of law, and you only need to look at the shoehorned into the EU public domain documentation, and I can give you a link after the radio show. You can stick up on the website if you want, Darren, to actually be able to go to a site where you can download it. I warn you, it's about 750 megabytes, so several hundred PDF documents which show categorically that the Heath administration committed treason in order to bring us into the EU. They got their own offices to write out thousands of postcards saying that the people, pretending to be the people of England and Wales, supporting our move to join the common market. And it's all in that documentation that proves that the government at the time orchestrated it. So all we need for lawful rebellion is to get the treason matter into court, and that's going to be the critical thing. So we've got two directions that we can go. One is the whole country stands up under the British Constitution and takes back its power, or two, those of us who are prepared to stick our heads high enough above the parapet in lawful rebellion to get ourselves ultimately into a high court of some kind, and actually bring the evidence matter of treason into the court. Because once one act of treason has been proven, then all the other acts that follow it become void ab initio, in much the same way as a void order of the court. Mm-hmm. And the fact is that because the Heath government committed treason to get us into the common market, into the EU, we haven't actually ever lawfully been in the EU, because a crime of treason was committed in order to get us into the EU in the first place. So that's the thing that we really need to push, and that's one of the driving forces behind lawful rebellion. It's not anti-Europe, but it's anti-European Union, which is something very different from the continental Europe. If you look at the 1942 Red House report, a number of very, very senior Nazi officials got together, generals and Nazi officials, and they decided that in 1942, if the Nazis were unable to win the Second World War militarily, that they would instead achieve dominance by the use of corporations. And in 1942, the European Economic Community was created at this meeting in 42, and you can find the document in question listed on our website, or access to the document listed on lawfulrebellion.info, which proves beyond any shadow of a doubt that the European Union was the brainchild of the Nazis right back in 1942. And if you look at what they've actually accomplished, they've almost taken us over now, Darren, haven't they? I mean, already Parliament is pretty much subservient to the European Union. All of our court decisions have to be compatible with the European, European human rights, etc. They control most of our corporate regulations, the red tape that's imposed on us, and almost every facet of our lives, one way or another, is being tainted or tinged by the touch of this fascist, unaccountable. You can't really call them a government because they don't govern, do they? And so that's the driving force, one of the main driving forces behind Article 61 and lawful rebellion. It's about restoring the sovereignty to the people, restoring the sovereignty of the country, standing under law, and bearing in mind that, going back to our Declaration of Rights 1688, that no foreign prince or prelate can have power over or dominion over our country. And the consecutive governments, starting with the Heath administration between 1972, our consecutive governments have all done nothing but lead us further and further and further into this Nazi-created organisation. And in 2017, it looks like we'll be having Eurogen 4, the European armed police, but will be patrolling our streets. And, I don't know about you, Darren, but I really don't much fancy the idea of having armed European police who have diplomatic immunity wandering around the streets, because, if that happens, then we finally reach the point in history where all of our rights will have been replaced with revocable privileges. And that's the unfortunate thing about the Human Rights Act and the European human rights. If you look at them in minute detail, the reality is that actually they start with the idea that actually people have no rights unless they are given by the state, which is completely contrary to our way of doing things under common law in England and Wales, where we start off with unalienable rights that can never be eroded, or should never be eroded. And the final ratification, or the so-called referendum, which I don't know about you, but I've got absolutely no confidence whatsoever that any referendum will actually surface. If we want to stop this, if we want to save ourselves from being gobbled up and living in a European superstate that is run by unaccountable people, effectively, then sit down and do nothing. But if you don't want that in your future, then standing under Article 61 and then in doing something about it is one possible mechanism. And I'm really confident that if you put these two things together, Grand Juries and Article 61, it pretty much restores our power as the people of this country to hold our public servants, and I emphasise the word servants, they are public servants, it gives us the power and the ability to hold our public servants to account for the numerous or innumerable crimes that they've been committing against the people of this country.
Absolutely. Some people may find themselves in desperate situations. Well, I know, in fact, that there's lots of people up and down the country who are in desperate situations and feel like, there's possibly no way out. But these are real mechanisms within law that give us remedy, Nige.
Yes, and that's something that's well worth considering. When you look at the uptake of food banks and the descent into poverty by people, all across the country, it really is so saddening. And I can't set myself apart in that instance. I mean, some of your listeners will know me, a great many of them won't, but I'm severely disabled. I had unsuccessful spinal surgery in 2004, and I've been left with spinal damage, and walking is a serious problem for me. I use a wheelchair most of the time. And I'm actually facing repossession myself right now. So where Tom Crawford has been over the last couple of years, I'm actually on the precipice of that very situation myself. So when I talk about people that are potentially likely to be or already have been dispossessed, I cannot separate myself from them because I'm actually in the same position myself. So I hope that Tom Crawford is. I see from the internet this afternoon that they're looking to try and get enough people back there to get him back into their property, and I wish him all the luck in the world. He has the right to live in his house. He paid for that house over 25 years, and for them to have taken it without a judgment it's not just described as criminal. It is a real, genuine, bona fide criminal act, and which needs attention. So, anyone out there that's listening to this that's facing repossession, my heart's with you. I'm there myself, my friends. So, we must continue fighting together, using all the remedies that we've got. Be peaceful, be honourable, which is one of the other important things about living in common law. Always be honourable. Because 9 times out of 10 your opponents are the people who are dishonourable, and that always gives you an advantage in law. So be peaceful, be honourable, and take advantage of the fact that our ancestors had the wisdom to put laws into place, or not laws, clauses if you like, in our constitution that give us remedy for the situation that we find ourselves in right now. In 2015 and beyond, and let's join together, people. Let's get rid of all of the fragmentation that's occurred, and the clamouring for recognition. Is at the end of the day, we're all on this island together. We all need to work together to make this place a nice, livable, lovely part of the world to be in. England, Wales, Scotland, the British Isles, I think they're a lovely place. It's where I come from, and I believe that our ancestors had the wisdom to put it into effect, the remedy that can protect us from this ensuing fascism, Nazism. I don't know what else to describe it as, Darren, but sometimes they're shoving it down our throats. Time to start fighting back.
Yeah, it's difficult to find words to describe the system on times, Nige.
Yes.
But these mechanisms are there, and now's the time to invoke them. As we mentioned earlier, we've had one test case in South Wales, and there's been 2 others within the UK. By the way, if anyone would like, apart from listening to the excellent information that Nige has given us to follow up on, if anyone would like to hold Grand Juries, Nige is on our Facebook page. He's willing to help. We've also got a Facebook page dedicated to Grand Juries, Nige. And would you like to mention any other pieces or information that people may be able to find helpful, or any websites Smith?
Yes, I mean, really, I think one of the beauty both about grand juries and about Article 61 is that it's not complicated.
No.
It doesn't take lawyers to sit down and read it and understand, and that's what I really like about it. So, as far as lawful rebellion is concerned, or standing under Article 61, there are a few sites out there that come at it from various different angles, but for our group, that's kind of based in Glastonbury, if you like, we've put up the site lawfulrebellion.info, and it's just one word, lawfulrebellion.info, and that breaks down what lawful rebellion is about, what it involves, how to stand under Article 61. There's a video on there where David Robinson talks about Magna Carta and Article 61, and also Sandy talks about Agenda 21 too. But also on that same website, there's a little section called Quick Law, which gives you some quick insight into some of the issues. Like, for example, once you're standing under Article 61, they can't really touch you with statute law because you have lawful excuse. But one of the things that the police can still get us on is breach of the peace, which is common law and not statute. And so we've got on there the definition of breach of the peace, so that you know precisely what the police have to, what evidence the police have to have in order to be able to arrest you under a breach of the peace. There's a little bit about habeas corpus, how to invoke habeas corpus. I know they keep saying habeas corpus has been repealed. Well, no, it can't be, because it's all part of our historical law, common law. Swearing at the police, there's a little bit thing about civil arrest. Quick thing covering the myth about de-arrest. I've heard some police occasionally out in the world of activism saying that, right, I'm de-arresting you now. No such thing exists. So that in itself is a misconduct. And an important one, power of attorney. If you're getting involved in activism, then one of the things that you can do is set up a general power of attorney. It's a bit different from a lasting power of attorney, which is what you would use if maybe one of your relatives is starting to lose their mental faculties. A general power of attorney, what that does is that you get a couple of your friends to sign up a general power of attorney, which gives them the right to act on your behalf in areas of law, perhaps, or in law enforcement. So if you get arrested, and quite possibly unjustifiably so, what often happens is your relatives, they go to the police station, or your friends, they go to the police station and say, can you tell me what's happened to Nigel, please? And the police will say, no, sorry, can't do anything. Data Protection Act. And they're actually using the police a lot now. They're using the Data Protection Act as an excuse to fob people off, so that they don't know anything, can't do anything. Well, if you give your friends, a couple of your friends, a general power of attorney, then they can waive the general power of attorney in front of the police, and then the policeman has to talk to you as though they are talking to the individual that they've arrested, and that's a fantastic little bit of power that you can have. So that's all on lawfulrebellion.info. We've got a Facebook page which is Practical Lawful Dissent. It's one enormous long word if you type it out, but you should be able to track it down. Very often it points you to British Constitution Facebook pages, but there is Practical Lawful Dissent. I'm sure we can get a link up on the website with Darren.
Yeah.
There's the Grand Juries Facebook page, which was originally set up with the idea of it being principally for people who wanted to be the administrators of grand juries, people that could learn the ropes of convening grand juries and help guide individual grand juries that popped up around the country. That modus operandi seems to have been eroded a little bit, and now we seem to be getting people just joining willy-nilly, which is fine. And at the end of the day, it's all about informing and educating. So on Facebook, you just go to the British Grand Juries site or page on Facebook. Its proper title is British Grand Juries. That's it. It's only a small group. There's 106 members at the moment, but there's a couple of things in the files in that section of Facebook that gives you The general modus operandi that I blurted on about earlier, about how to convene grand juries, the oath is on there, and witness statements that you can print out, so in order to be able to get witness statements written down and produced ready for a grand jury. So that's all on there. So those are the only sites that, between them, I suspect you could find all the information you want.
Yes.
So Practical Lawful Dissent, Facebook, lots of people on there, so it tends to be quite noisy, as you know. Facebook tend to get a bit noisy these days, and people wanting to put up the things that they found, so it comes out, it can be a bit difficult to keep track. But yeah, Practical Lawful Dissent, that's where you'll find me. Lawfulrebellion.info is where you'll find all the information you need about Lawful Rebellion. And British Grand Juries on Facebook is the place to go to start getting your teeth into how to convene a British Grand Jury. I think that pretty much sums it up, Darren.
Excellent work, Nige, and thank you very much for giving us your time. And I'm sure I know this is going to be invaluable information. And again, I thank you on behalf of everyone here, the Common Law Court of Wales, and all our listeners, mate. It's been fantastic.
It's been a privilege to join you, Darren, and I'm in awe of the work that you guys have accomplished, and power to your elbow. Together, all of us, we can do something. We can bring this country back from the precipice if we work together.
Yeah, we've already had one case here in South Wales with the likes of yourself, who were able to give us invaluable advice, and these are real, tangible mechanisms in which we can help fight off this fascist corporate regime that seems to have basically taken over, Nige.
They have. They've completely taken over. Even in the last few months, I've seen an acceleration in what they've been doing. The eviction in Moss Side, where I don't know if you recall looking at the video evidence that took place in that one. There weren't any bailiffs present. They evicted this man, and there were no bailiffs. The police did it, and that is illegal. Period. We've got to take these people to task.
The stories are unbelievable. We had a gentleman with the name of Kevin Bedwell, and not only did the police come, but they also had the social services threatening to take his grandchildren.
Yeah.
Unless he left the property. So we have all these services, if you like. We've got the police service, we've got the social services, all conspiring with the bailiffs and the courts in order to asset strip the common man and woman.
Yeah, yes indeed. The banks are pretty much insolvent now, and all they are interested in is our property, because that's the only bit of material solvency that they have got left. They announced at the beginning of the year that they were going to repossess 70,000 homes this year in Britain. How did they know they were going to repossess 70,000 homes, Darren?
Well, it's just as cold-hearted as a fact of they need X amount of money, and that's the amount of houses that will provide that in order to keep these banks afloat. Yeah.
And as we wind this up, there is one thing that I really, really do want to stress. So hopefully you can't hear my cat's having a go at me now. One thing I really want to stress, from my perspective, everything that I'm seeing going on at the moment, the government appear to be trying really, really hard to create civil unrest. We've got the racial tension thing going on again. We've got the whole Muslim fear factor thing that's being pushed around again. We've got the low paid and the people at the bottom end of the financial scale being harassed and dispossessed, and benefits are disappearing entitlements disappearing one after another. And so, what we've got is very soon we're going to be in this situation quite similar to what we had with the poll tax riots in the 80s, where people will become so disenchanted with life that the anger will bubble up and eventually it'll surface. And at that point in time, that gives them the opportunity they need to state martial law, and we need to avoid that, Darren. We need to rein in the anger and convert it into some kind of positive action. Cause no harm to anyone. Even the nasty policeman, cause no harm to them. There are other ways of dealing with this. And if we engage in widespread violence and disharmony and rioting and stuff like that, it just gives them the excuse to install even more restrictions on us. And it's not on. So please, I beg of everyone, please don't resort to violence. Use our Constitution. It's there for us to use. We have it. We can use it. We've been using it with success. So let's continue using our Constitution to fight the injustice that the New World Order appears to be trying to bring down on our heads.
Well said, Nige. Quite right too. I think I'll do us, brother. Thank you very much for coming on. And
splendid. Okay, Darren. Yeah, thanks very much for that. It's been a pleasure. Sorry, I once I get going, I do tend to wither on a bit.
No, the information is very important, and the message is just as important. This needs to be peaceful, and it is powerful, as you've documented, and people can easily research in the threads that you've given them there. And of course, we'll put everything in the description box, both in the Blog Talk Radio description and the YouTube channel. When we put it up there, all links will be provided for people who would like to follow it up.
Possible for a grand jury not only to convene anywhere, but should they find a true bill, that presentment can be made at any magistrates' court in the country. And that in itself is very significant, because a lot of people, I'm sure, would thought to themselves it would be lovely to be able to convene a grand jury and find a case to answer against various persons in public office that have committed misconduct, malfeasance, misfeasance, nonfeasance, whatever. But then thought, well, yeah, but okay, even if we get a true bill, someone then has to drive all the way to London, and we don't all live in London. It's 150 miles away for me, and probably a little bit more than that for you. So, not many people would want to have to drive all the way to London in order to be able to continue the legal process. And so the fact that we can make presentments at any magistrate court means that the possibility for convening grand juries is open to just about anyone. And significantly more convenient than we thought it was back several months ago when this system first kicked off. And just to be clear on it, this is still fairly new territory for us, because no proper grand juries, that were constitutionally convened, hadn't been done before the spring of 2015. I know that there was one sort of held last year under a slightly different guise, but from a constitutional point of view, and using this process, we've only just started holding grand juries again in 2015. So this is new territory. I was fortunate enough to speak to John Hurst a few weeks ago, and that was when I learned that it would be possible for grand juries that the result from grand juries, the presentment, to be made at magistrates' court. I learned that from him then. At that point in time, 3 grand juries had been held, one in South Wales and 2 in England, one of which was in Worcester. Now, the one in South Wales, the institutional safeguard and prove of immense value. Now, I am sure, Darren, you can see the wisdom in those words, and it's almost like the Marquis of Hartington could look forward 60, 70 years hence and see the situation that we're in now, where we have exactly that. We have a fascist government which is trying to control absolutely every facet of our lives, and it's terribly, terribly frustrating. Anyway, grand juries, as I say, they thought they abolished them in 1933, but grand jury is also a common law right, and you may be able to set aside common law, if you like, put it away, slumbering, waiting for resurrection at some point, but you cannot remove it, you cannot repeal it, and that in itself was one of the saving graces. So, although the grand jury's right to indict people directly was impliedly and explicitly repealed in 1933, the right for a grand jury to make a presentment was not repealed in that 1933 legislation. And this is really important, because the right to make a presentment remains unrepealed from Statute the 5th, 1351. And this is one of the key aspects of where grand juries actually can come back into the picture again. Statute the 5th says, no one shall be taken upon suggestion without lawful presentment, nor disenfranchised but by course of law. Paraphrasing, according to Magna Carta, it says, it is accorded, assented, and established that from henceforth none shall be taken by petition or suggestion made to our Lord the King or his council, unless it be by indictment or presentment of good and lawful people of the same neighbourhood where such deeds be done in due manner. Conditions, if you like, of grand juries. Because grand juries in England and Wales were removed, they were taken away from us in 1933. There were a number of attempts to kill grand juries prior to that, going back as early as 1848, I believe, where the establishment began to feel that they were suitably qualified to start taking decisions like this away from the people. And as a result of the Administration of Justice Miscellaneous Provisions Act 1933, at midnight on 31st of August 1933, grand juries were repealed effectively. And the authority, if you like, of the grand jury was placed into the hands of magistrates. And so indictments which up to that point in time could have been dealt with by a group of ordinary everyday folk coming together and considering some evidence and determining whether there might be a case to answer, that right was effectively taken away from us. That was somewhat 80 years ago or so. Now, as a result of, obviously, John Hurst being a constitutionalist and constantly looking into law and delving into the Constitution and into the law, and I believe some work also by Michael Bernicia, it was discovered that grand juries weren't properly repealed in 1933. Now, when the grand juries were repealed in 1933, it's a rather interesting little snippet I've got here. Just one MP in the debate for the repealing of grand juries, just one MP spoke up in favour of preserving grand juries. And the Marquis of Hartington said, suppose it came to pass that we had in this country a fascist government which created a whole mass of new offences, such as holding views disrespectful of the government. In such a case, the grand jury might be a very constitutional...
Welcome, ladies and gentlemen, to the Common Law Code of Wales radio show. We have a special guest, Nige Coleman. Been doing excellent work on formulating grand juries. Can you hear me all right, Nige?
Yes, absolutely splendid. Much easier than the last conversation we tried to have.
That was something, wasn't it? Just for the listeners, me and Nigel tried to touch base yesterday, and it was, well, we tried several different mediums. In the end, the good old landline got it, but somebody didn't want us talking, that's for sure, Nigel. I think I'll leave it at that. What do you think?
Well, yes, indeed. Always leave them wanting more. But no, it's been a long time since I've had that kind of difficulty in establishing contact with someone. It was quite disturbing, really. But well, at least we're able to talk today. So,
grand juries, within a particular critical time in our history, where we find the governments and the courts are totally run away and abandoned our law in order to facilitate, basically, fraud and asset stripping of the people. So where did this concept come? How did you come across this remedy, Nigel, and exactly what is it?
Okay, well, actually my first exposure to grand juries, British grand juries, was at the British Constitution Group annual conference in spring this year, 2015, end of February, beginning of March, where John Hurst did a presentation on grand juries, and also as part of that conference, the guys there convened a number of grand juries to consider various charges that were being brought against individuals in public office. And at the British Constitution Group conference there, we successfully had enough people to convene 4 grand juries. And I was honoured to be a juror on one of those juries. Now, of course, I can't talk about what we considered as the jury, because that's part of the grand jury process. But John Hurst gave us a considerable insight into the legal and the lawful or by process made by writ original at the common law. And finally, if referring back to Blackstone's commentaries on the laws of England, it says the next step towards the punishment of offenders is their prosecution, or the manner of their formal accusation. This is either upon a previous finding by an inquest or grand jury, either by presentment or indictment. And so the crux of this, and the great thing about it is that in 1933 the government thought that they repealed grand juries, and they did repeal grand jury indictments, but they didn't repeal presentments. And so therefore British grand juries, British runaway grand juries, continue to be both lawful in common law and legal in statutory law. And that means that we have some significant power that we can still wield at this point in time.
It's absolutely critical, that, Nige, because there's no bypassing it. As you say, it's not been repealed, therefore it is lawful and legal.
Indeed, indeed. Now, what we first thought, and what was first presented at the British Constitution Group by John Hurst, it was originally thought that it would only be possible for a grand jury could be convened anywhere in the country, but it was understood at that point in time that the presentment which a grand jury, the foreman or the private prosecutor, the private prosecutor of a grand jury would make, thought it could only be, a presentment could only be made at the Old Bailey, because in the 1933 legislation, grand juries for the county of Middlesex weren't repealed, and therefore the catchment area of the Old Bailey, being Middlesex, meant that in theory you could hold a grand jury anywhere, but the presentment would actually have to be made at the Old Bailey. It's since come to pass that in itself isn't correct, and indeed it would appear that it's possible